Hello and welcome to this webinar. I'm Lucy Temple-Smith, Senior Advisor, Advocacy and Communications at the Global CCS Institute. I'd like to give a big welcome to our international audience. We have attendees from around the globe joining us today. We did have 1 hour scheduled for this webinar, however, we do expect it to only run to around 30 to 40 minutes, including questions. Liability has long been raised as a significant barrier to the wide-scale deployment of carbon capture and storage. This webinar will draw on the key analysis and findings of our latest thought leadership report that seeks to challenge these views and make the case for a more commercially minded view of liability. All attendees are welcome to submit questions throughout the presentation through the Questions tab on the GoToWebinar control panel on your screen. Questions will be moderated and posed at the end of the presentation. Please be aware that we may not be able to answer all questions today. However, we will endeavour to get through as many as we can in this session. Let me now introduce our presenter, Ian Havercroft, Senior Consultant, Legal and Regulatory here at the Institute and the author of the report, who will begin the webinar. Thank you, Ian.
Thank you, Lucy. Welcome everyone to today's webinar. As Lucy said, I'm going to spend the next 20-25 minutes giving you a high-level overview of my recent thought leadership report, Lessons and Perceptions, Adopting a Commercial Approach to CCS Liability. I'm going to start by providing some context to the study. Sorry, bear with me one moment. And some context to the study and an overview of the liability challenge. As we've just mentioned, liability has long been highlighted as a critical issue for CCS deployment. Liability has long been highlighted as a critical issue for CCS deployment. It was consistently raised in many of the early studies which considered the critical issues for deployment or the design of legal and regulatory frameworks. In particular, the IPCC Special Report on CCS and many of the early IEA legal and regulatory studies. Within this early analysis, assessments as to the scale of liability were intrinsically linked to the perceived risks of the technology. And many of you will be familiar with the risk model proposed by Professor Sally Benson of Stanford University and her risk curve, where the perceived risks centered upon the likely security of storage sites and leakage profiles, the challenges of long-term permanent storage beyond the lifetime of many governments and commercial organizations, and the novel application of the 3 aspects of the CCS process for the purpose of climate change mitigation. Many of these issues have now been addressed by policymakers and regulators to a greater or lesser extent in the early policy and regulatory frameworks that we have seen developed over the past 10 years, several of which were examined for the purpose of this report and in some of the Institute's previous analysis. In many instances, legislation has been introduced to address the specific issues that were identified in many of those formative studies that I mentioned earlier. However, despite these developments, the topic continues to be raised as an issue and a potential showstopper for projects. Unfortunately, it's often raised in a very broad manner and it is rarely qualified. It's simply just liability is an issue that projects face. And then subsequent to that, very few solutions are proposed or highlighted. It's also perceived as a critical issue by those seeking to develop legislation. While undoubtedly an important issue, I'd question whether it should be seen as an impediment to deployment. Within this context, and the challenges that I've set out in that earlier slide, what we decided to do was to address the current status quo, and that proved the rationale behind this particular study. And as such, we set out 4 objectives for the study, which are set out on this particular slide. The first was to review various legal and regulatory frameworks which had sought to address liability throughout the distinct stages of the project lifecycle. Second was to examine project level responses to early liability models. start to draw out both the positive experience and perhaps some of the remaining challenges. Within the practical experience to date, policy, regulatory and project proponents consider the successful approaches to liability, essentially what has worked. Also looked at some of the wider literature and analysis that is aimed at addressing some of the remaining or more challenging issues where legislation is unclear or is yet to fully address the issue. And then finally, I wanted to really identify the critical issues which may impact deployment. In undertaking analysis for this report, I undertook very wide desktop research, and that included academic review as well as legislative and policy review. I also conducted interviews with several policymakers, regulators, lawyers, project proponents, and insurance sector representatives, both here in Australia as well as in Europe, Canada, and the United States. And our final report was independently peer-reviewed. Over the next few slides, what I'd like to do is examine some of the report's findings in greater detail. The first area is legal and regulatory development. As I mentioned, in the past 10 years, several jurisdictions have developed CCS-specific legislation, and many of these regulatory regimes have sought to address the issue of liability. We've seen legislation at the regional level, national level, and then indeed the state and provincial level. One example of regional level legislation would be the EU CCS directive, as I've highlighted on this first point, which has now been implemented across the EU member states. At the national level, we have liability provisions within the Australian Commonwealth Act, which governs the storage of CO2 in offshore waters. And at the state and provincial level, we have a range of different pieces of legislation. They range from highly detailed provincial legal and regulatory frameworks that are found, for example, in the province of Alberta in Canada, through to perhaps more discrete liability provisions found in some of the US states. Many of the models developed to date have addressed liability throughout the project life cycle, but some have focused upon, well, more largely upon the challenges posed by the storage aspect, and indeed permanent storage. And I use that term because it's found within a number of pieces of legislation, particularly within Europe and Australia. The necessary long-term timeframes and the post-closure period following injection operations were really central to some of the liability regimes that were developed in those early frameworks. In my third point, I think it's important to highlight that was very evident from the analysis is that many policymakers and regulators have adopted quite similar approaches to the management of liability. They have included CCS activities in many instances within the scope of existing liability legislation. One example here would be the EU directive's application of the Environmental Liability Directive to CCS activities. And this is particularly true when you look at those liabilities that likely apply to the operational phase of a CCS project. In the United States and Canada, where property law considerations are significant for liability, some states and provinces have sought to clarify title and tenure issues, and an example here is found in Alberta's legislation. The front loading of risk is another common aspect to many of the early regulatory frameworks. Here, perhaps the idea is that reducing risks early in the regulatory process will likely impact the risk profile of a project later in the life cycle. So if you imagine the Benson curve into the longer tail of a project, front loading those risks will obviously lighten the load, so to speak. Several models have also sought to address the concerns of operators and the public and provide for the transfer of responsibility for a storage site or the stored CO2 from an operator to a competent authority at some point in the post-closure period. And this model's been adopted within the EU directive, Australian state and federal legislation, and again in the province of Alberta. And then the final point here is the issue of financial security, and several models have employed financial security provisions as a means of addressing the various liabilities incurred by an operator over the lifetime of a project. with some highlighting the fact that this limits the exposure of government and thereby the taxpayer. When I was reviewing these various legal and regulatory frameworks, one of the things I tried to do was perhaps more carefully define, when considering all the different regulatory regimes that I looked at, what is exactly meant by the term liability. And in this particular piece of analysis, and indeed this builds upon the work I did back in 2015, I suggest that there are perhaps three largely distinct forms of liability, and these are obviously highlighted in the table that you can see in front of you. Civil liability, liability that perhaps may be owed where another party seeks compensation caused for damage caused by CCS operations. And I've highlighted here in some jurisdictions, common law jurisdictions in particular, this is the term tortious liability. And these, depending upon the jurisdiction, can be determined within legislation or through principles developed through the decisions of the court. So, for example, things like trespass and nuisance. Administrative liabilities, which are imposed upon an operator in the form of requirements to do or not to do something by an by a regulator. Sorry, these are found within perhaps the broader body of national energy and environmental protection legislation, as well as some of the early CCS specific frameworks. And these are largely derived from a regulator's or a competent authority's statutory powers. They're very wide-ranging in their scope, and as such are perhaps difficult for some operators to quantify or indeed assess when they're looking at the issue of liability for during CCS operations. And then the final category is greenhouse emissions and climate liabilities. I've suggested that this may be a form of administrative liability, but it's very specific to CCS, and therefore, as I'll talk about and you'll see in the report, presents some very difficult issues for operators and indeed regulators. But these are the types of liability that may be borne by an operator where they receive credit for storing CO2 under perhaps an emissions trading scheme or a crediting scheme, and then there is subsequent leakage and they're required to either purchase allowances to cover this leakage or pay some sort of equivalent fine. So with that overview of the legal and regulatory regime, what I'm now going to look at is some of the experiences and perceptions of the issues of liability, over the past few years. In particular, those perspectives of project proponents and regulators, and many of these observations were drawn from the interviews that I undertook in the preparation of this report. In several instances, the liability provisions that have been developed to date have now been implemented by regulators, utilized in some instances by project proponents, but they have also been subsequently reviewed as part of national review processes, or in the case of the European directive, the EU directive review, which was undertaken in 2015. And I've just listed three regulatory models there which have been through this process. The first is the EU directive, which I mentioned that in 2015 was reviewed and was determined to be largely fit for purpose by the Commission. The Victorian government's regulatory framework, regulatory assessment, which was undertaken in collaboration with the Global CCS Institute, where the Victorian government took an analytical review of its regulatory model to determine whether there are any gaps or improvements that could be made. And then the Alberta Regulatory Framework Assessment process that was undertaken, and a final report to government was provided with with a large number of recommendations for the further expansion and approval of the regulatory model. Within all of these frameworks and indeed the review processes, it was determined that liability had been addressed, but there were things that could be improved to strengthen it. But largely, many of these programs were fit for purpose and had gone a long way towards addressing some of those issues that were highlighted in the very early studies that highlighted liability as a particular problem. So there's some very positive elements from that. Notwithstanding that, there were a number of areas where it was felt that these regulatory frameworks could be improved, and to some extent, and in some instances, these improvements are already underway. My second point, and perhaps the most encouraging observation from the study, was that projects held a largely positive view of liability provisions. In many instances, projects viewed the liability-specific provisions of their regulatory frameworks as largely manageable, and a number of interviewees that I spoke to praised the certainty that the regulatory framework had afforded them in understanding the extent of their liability obligations. There are, however, a number of issues which clearly remain, and one notable example here was the issue of climate liabilities and how those were to be managed, particularly within some of the within the EU directive and national implementation. Concerns were also raised in instances where there was ambiguity within the regulatory framework, or where regulators were yet to take a clear position on liability. The other area I looked at was in relation to the likely magnitude of the financial risk posed by liability. And this has been consistently raised by operators, regulators, and those seeking to finance or perhaps ensure that CCS projects. There have been a few studies, perhaps not in recent years, but they have sought to consider and indeed in some instances estimate the scale of these risks. And these have included some technical academic studies as well as some project level analysis, which was undertaken as part of the UK commercialisation project, commercialisation programme. And those studies were obviously available from both of the two projects, the Peterhead project and the White Rose project. And it's not possible here to provide an exhaustive analysis of all these studies, and they are detailed in to a greater extent within the report. But their value, I think, was particularly should be highlighted here. They not only demonstrated that it was possible to look at some of the financial liabilities in greater detail, and the associated probabilities with those financial liabilities could be modeled in certain circumstances. But a positive message which I took from some of these studies was that where you had an appropriately sited and well-operated CCS project, there appeared to be a relatively small potential for significant damages. The corollary to this is obviously that these studies were highly project specific, in some instances perhaps a little dated, and they may not reflect some of the improved technical outlooks for the technology. But again, as I said before, very, very useful and demonstrate that perhaps the magnitude of the financial risk posed by liability is perhaps not as great as originally anticipated. My final point in relation to experience and perception concerns the technical outlook for storage. In reviewing some of the academic and technical literature around storage, I think it would be fair to suggest that there is now a higher confidence in both technical feasibility and storage security. The IPCC special report on CCS included high confidence in the environmental effectiveness of the technology, but I think this has been further bolstered by a number of years of research and development, and indeed project level experience. I highlighted one particular report within my report, and that was subsequently published in their Nature Communications paper. And this was the findings in relation to the storage security calculator, the SSC, and the paper is Alcade et al. And I noted in particular the quote there that in a realistically well-regulated industry with a moderate density of legacy wells, their program calculated a 50% probability that more than 98% of the injected CO2 will remain trapped in the subsurface over 10,000 years. The greater and higher levels of certainty we have around storage permanence and storage security will be really important, and hopefully this can be communicated to decision makers, in turn providing them with greater confidence in the security of storage, but hopefully in tandem with the regulators, And this brings me onto the final part of my presentation and the ultimate conclusion of the work that I did here, and that was the adopting of a commercial approach. First, I should point out that I think, as I stated previously, the analysis undertaken in the compilation of this report suggests that liability is perhaps not a potential showstopper for the technology's deployment. However, what we are advocating is perhaps what we've termed a more commercial approach to liability. This would see a greater shift away from broad academic reviews of the topic towards a more dynamic, proactive approach. And this would see greater collective review and engagement with the topic, both to address the outstanding issues and ensure that project deployment isn't frustrated by what I see as perhaps a broad colloquial term. And in adopting this approach, I've highlighted a number of areas which I think merit further consideration. And I'll just go through these briefly in the next two slides. The first is to refine our definition of liability and shift away from perhaps more colloquial language and focus upon some of the specific categories that I highlighted in my earlier slide in that table, the civil, administrative, and climate change greenhouse gas liabilities. During the interview process, one interviewee pointed out to me that we've done a disservice to ourselves to focus on this broad catch-all category, as it sort of looms as one ostensibly immovable issue that we can't get past. In fact, breaking it down into the smaller categories of liability, I think, allows us to address some of those jurisdictional project-specific issues. It also allows potentially a greater opportunity to focus upon addressing what I've called the real issues in this point, and that would be climate liabilities. One category of liabilities which was raised a number of times both in the literature and in interviews. Analysis clearly revealed the significant role to be played by both the government and the private sector in addressing liability. In the case of government, and I mean obviously here regulators and policymakers, clarity in the legal and regulatory environment has been a critical factor for investment and project proponents more broadly. Certainly ambiguity has led to delay for projects. One area in particular which I can highlight here is the idea of burden sharing and potentially liability caps. Within the second commercialization, the competition in the UK, it was suggested in a report following the conclusion of that program that there may be an opportunity for government to offer support where specific insurance products don't exist, or smaller operators may find it hard to self-insure particular risks. The government may offer support in the form of burden sharing or the setting of liability caps to help those early movers and address some of those liabilities. The role of the private sector is another area which can potentially manage some of these liabilities, and that may be in the form of commercial agreements to address a range of liabilities, and these may take the form of liability apportionment mechanisms that could be found in commercial contracts, for example. In existing oil and gas contracts are one example where there may be useful analogues for CCS operations. Financial security clearly has a very significant role to play in addressing liability. Not only is it very well understood by operators and regulators, it can be seen as quite a practical approach to managing risks associated with the process. There are a number of examples to date, and I've referenced them in the wider report, where financial security has been used in the regulatory framework to address a range of liabilities throughout the project lifecycle, including into the post-closure phase. A very nice example of that is found in the low carbon fuel standard and the buffer account, which I think provides, and I've gone into a little bit more detail in this in the report, but it provides a very practical approach to the management of a range of potential liabilities. And I think it allocates very nicely responsibility between both the operator and the regulator. My second point on this slide, I think, is a very significant one, the need for a very reviewed scrutiny of the dialogue between regulators, proponents, and the insurance sector. While it's clear that self-insurance has been used very widely to date, new forms of insurance products may be necessary to address some forms of liability throughout the project lifecycle. And you'll note that from there's a very interesting table provided in the report, which comes from the Shell Peterhead project, which looks at the type of liabilities and how they are to be insured. Clear from that is that, as they viewed it at that particular point, not all forms of liability could be adequately managed through existing insurance mechanisms, and perhaps new products would need to be developed. As a result of that, the insurance sector will need to develop new products and engage with the CCS community more widely. And I think that will be an important aspect of developing products, insurance products going forward. And then my final point is in relation to the regulatory relationship between the regulator and the project proponent. And time and time again within my interviews and the academic literature, it's clear that in addressing liability, it will be necessary for both parties to have a robust and practical relationship, particularly where they're trying to navigate some novel aspects of the regulatory framework, or indeed some of the secondary provisions in relation to things like financial security and the timings of those particular issues. So that will be a critical way of addressing some of the liabilities going forward. My final slide shows the two complete institute reports on the topic of liability, one that was completed obviously back in 2014 and the one that I was talking about this evening, today. The Institute views liability as a significant area of interest. It's an ongoing work program for the Institute. We're very keen to continue to share knowledge on the topic, informing our members and stakeholders, but I would welcome if you have any further questions or interest in discussing the topic, receiving further information or for the Institute to undertake further analysis here, if you would contact me, I'd be very happy to speak to you. And here's my email address. Thank you. Back to you, Lucy.
Thank you, Ian. Now, and just a reminder that you can find both of those publications on our website in the publication section on globalccsinstitute.com. And thank you to everyone who has asked questions today. We have time to go through some of these now. So Ian, the first one is around the different types of liability. And could you comment on apologies, everyone. Thank you to those who have asked questions today. We have time to go through some of these now. In the first question is around the different types of liability. Could you comment on which you see as potentially more significant for CCS deployment?
Okay, thank you, Lucy. One of the things that I wanted to test when I was undertaking the interviews as part of this report was some of my preconceptions as to the scale of these individual liabilities. Initially, when I set out on this project, I assumed that civil liability, for example, and some of the common law liabilities in relation to trespass and nuisance, for example, would be easily managed by projects. And I think looking more closely at the US example sort of highlighted perhaps this isn't the case. While it may be, they may be readily dismissed in some of the countries which have addressed, or jurisdictions which have addressed the property issues. I think in the US, this is very much a live issue. So I think there's just an example there by saying it really does depend on where you're based as to the significance of some of these liabilities. In the US, for example, those may play a more significant role. I think it's clear, however, the greenhouse gas emissions climate change liabilities are potentially the most problematic. They're not readily insurable at the moment. And some of the conversations I had with project proponents, even where there isn't an emissions trading scheme presently, raised those as potentially a future consideration. So I think while there are examples of how they've been managed, they are liabilities which would merit further investigation and closer scrutiny. So I'm sorry, that's a very broad answer, but I think they all merit careful consideration.
Great, thank you, Ian. Next question is around the insurance sector. You mentioned it will play a significant role. What can be done to engage this sector further?
I think the answer is probably in the question. I think it really is a need to just engage. I know from some of the conversations I had with this sector, they had been involved very early on in discussions with regulators, policymakers, and proponents when some of the early projects were coming online. However, because of the perhaps fewer number of CCS specific projects that have of the type that we have seen in Europe, for example, coming online, they haven't been quite so readily engaged in discussions. As such, their not understanding, but their awareness of some of the technical developments or even willingness to engage in these conversations has waned recently. And it'll just be important to get them back into the conversation so they can start to hear some of the issues that are being faced by projects. As I mentioned earlier, they're hesitant, obviously, or unable to start developing projects unless there's a product, unless there's a market. So I think just broader engagement will help.
Okay, thanks. Thanks, Ian. And thanks to those who asked questions today. We will leave it there in the interest of time. However, if you still have questions, please feel free to make contact with Ian directly, as he has provided his email address, and also, of course, make contact with the Global CCS Institute at any time via our Contact Us page on the website. This webinar has been recorded and will be made available on our website, along with a copy of the presentation in the coming days. Thank you to Ian for presenting the webinar today. This is one of a series of expert webinars. I certainly hope that you found it valuable, and to hear more from the Institute, including our upcoming events and further webinars, I encourage you to subscribe to our monthly newsletter, which you can do via our website, globalccsinstitute.com. And just a reminder that you can find the publications, of course, the most recent one on liability and the previous one Ian mentioned, in the publications library, also on our website. Thank you all for your attendance today, and goodbye.